get a chance to remember. So now we'll hear from Chuck, Lindsey, and Jim Bucknell on some of the ins and outs of hydrology and engineering. Creative solutions.
Okay, I'm Jim Bucknell from RH2 Engineering, and if you don't know who we are a civil engineering firm headquartered in Bothell. There's about 75 people or so in the firm. We've got offices throughout the state and into Oregon. We've got 7 people here in the office in Bellingham. I am not an engineer. I am a geographer by education, and I worked for ecology for 27 years in water rights and water resources program before retiring from that and going to work for RH2 for a couple of years, which was 12 years ago. So it's worked out okay. So what can I say? I like it. So go ahead. So again, with me today is Chuck Lindsey from Associated Earth Sciences. I'll let him talk a little bit about his background and what he does, but we've been working together a lot on a lot of water rights work here in the county, and that's what we wanted to talk about today, because we heard Casey talk about the water rights framework and what can be done and how it's difficult to get new water rights and so on. So we're going to talk a little bit about the kind of work we have been doing, which allows some things to move forward. Okay. So there's a large backlog of water rights. There's, by my count, 626 in WIRA 1 pending applications and so on. And statewide, there's about 5,700. And so if you want to get something processed, moving ahead in the line is a good idea, unless you want to be number 627. And so that's some of the work that we've been doing. So the legislature created a process called the cost reimbursement process. And then ecology has identified 8 consulting firms across the state to be cost reimbursement contractors. And RH2 is one of those. And they've just, in fact, sent out the bulletin for the new one. So we're going to be reapplying, obviously, for that. So what's it mean to be a cost reimbursement contractor? Okay. So the next few slides will illustrate how this works. So there's 2 things that are going to be necessary for any water right transaction. You need a water right applicant, somebody who wants some kind of an action. Primarily what we're talking about is changes to existing water rights, but we've done it for some new rights, but most of what we've been doing has been in the cost reimbursement program has been changes to existing water rights. And of course you have the Department of Ecology, which is the regulatory agency that approves water right changes or new applications. There may be a technical consultant involved, and that's, in this case, Associated Earth Sciences and Chuck Lindsey that's worked with us a lot. And then there may be the cost reimbursement consultant to process the water right. So click again there. So the applicant, again, may elect to hire a technical consultant to assist with the application and supporting data. So Chuck helps people with filling out the application and also performs a very vital service, and that is sort of a reality check from ground zero, saying, you can't do that. There's no way ecology is going to let you do that. So don't submit the application, just figure out something else. Or he can say, yeah, that's probably doable, or it may be doable depending on what we find out with the specific data. That's one thing about water rights. They're very fact specific from one case to the next. So I used to get asked questions all the time, generic questions. Can I do this? And I'd say, well, I can give you, it's a generic question, I'll give you a generic yes or no. But it really depends on, you have to see what this exact request is before you can say yes or no. Next slide, or next click. So if the applicant decides to use the cost reimbursement process, he or she notifies ecology of that decision and then selects a contractor. We've really enjoyed working with Chuck because he knows Andy Dunn and I, who both have worked at ecology and now work for RH2, and he has gotten a lot of his clients to say, we want to do cost reimbursement and we want to hire RH2. So that's worked out well, thank you. Okay, and so if that happens, what ecology does is they ask us, they tell us, they give us the water right application, and we can look that up, and using the Water Rights Explorer and some other stuff, we look that up and check it out. And they ask us to prepare a scope of work and a fee estimate for processing the water right. And then we give that to ecology. If it looks okay to them, they share it with the applicant. Next click. And so if that looks okay to everybody, then ecology will contract with us for our scope of work and fee. And they will then also contract with the applicant to reimburse ecology for our costs. So next click. So the key thing is that when this happens, we actually work for ecology, not the applicant. We are processing the application as if we are ecology staff. And that's just important to know. So if there are questions or needed for new information, we go back to the applicant or their consultant, Chuck, to get additional information. But it's just important to understand the relationships between the various parties in this. We'll be asked, for example, on this, because we do a lot of work for municipal water systems and that sort of thing. One of the first questions the first question they'll ask is, do we have any conflict of interest? Have we already represented, the city of Sumas, for example, in building their water system or something, and now should we be processing their water right? And probably not. So we would exclude ourselves from that thing. We've only had one of those come up, and that was in Eastern Washington. But that's the very first question they ask. So anyway, if it goes ahead, then we go ahead and get the contract signed, and then we start working on the processing. And then I think at that point is where I click, if you would, and I believe, yeah, I'll turn it over to Chuck, and then I'll be back in a minute after he goes through his slides. So, oh, yeah, that part. Yeah, I'll need that too. Yes, you do.
So the last time I put one of these on was about 5 years ago. I was doing a presentation with about 400 people in Portland, doing a technical presentation. I was on at 8 o'clock in the morning, and everybody was in there half asleep, and the guy hooked the thing onto me. I took 2 steps forward, it flew off, it hit the ground, and it sounded like a small bomb went off from the auditorium. And everybody jumped about 3 feet, woke them all up. It's really great. Anyway, my name is Chuck Lindsey. I'm a senior hydrogeologist with Associated Earth Sciences. And my background, just really quickly, I guess to give you some idea in a local context, I got my master's degree in hydrogeology from Western here. Yeah, back Andy, when Andy was also in school there. We rode horses to school. Not together, but it was a long time ago. And I'm purposely not leaving Sue in this, I know that. But I've also known Sue for a very, very long time. I, at one time, actually was a water district commissioner for Lake Whatcom Water and Sewer District up here also. So I have some experience on kind of both sides of the thing. Back in the day, I actually was a consultant on the other side that Jim is on now in the cost reimbursement pool, processing water rights, but I haven't been on that side in a long time. Jim mentioned that we've worked together as a team for a long time, and it's true. It sort of seems that way. I tend to work with farmers and other people that are dealing with their water rights before they go to ecology to kind of help them understand what their options are, where their risks are, and things like that before we go there. And once we get to where we're going to go to ecology and submit it, I prefer to work with RH2 because I know that Jim and Andy Dunn over there know how to write ROEs very efficiently. They're very good at it. They're very cost effective. And I do recommend them a lot to my clients. They do great work. How many people here are scared of water rights? Yeah, they're scary. They really are. And particularly if you're a farmer. None of them are the same in spite of the nice little certificate that Casey showed there. The thing that caught my eye was she went through the Water Resources Explorer. You'll notice she said you can pull up the water right and then you can look at the certificate and these other attachments. Well, the other attachments are the application, typically the report of examination, which is ecology's written out decision on the water right, the permit, and there's some proof of appropriation sometime in there and some things like that, and then the certificate. Those are typically the things that are attached. The details of the water right are in that whole body of work. And so it's not just that single page. In fact, if you just look at that single page, you will be led astray as to what your water right is. So it's important to kind of look at all those things. But to get back to, I guess, what I do is, and I'm not going to throw you under the bus, but in a way, I too act as sort of a liaison with the farmer, the person who's looking at their water right situation, between them and ecology. A lot of times you can look into a water right and you can find things out that maybe are best not known, to put it mildly. And it's just best to go, okay, maybe that's not something that we need to bring out in the light right now, and let's fix it. Let's figure out a way to fix it. There's an issue there. A lot of the water rights around here were granted back in the 40s, 50s, 60s, 70s by people's grandfathers, and they were for a very specific purpose. And then over the years, they took the water right, they put it in the safe or up on the shelf or something. They never looked at it again. Their operations morphed, their farms expanded, they changed things. A well went bad, they put a new well in. They didn't look at the water right when they're doing this. They just did it. Farmers are very practical people. They're very forward thinking that way. And now we come to a time when everybody's looking at them with a lot more detail, a lot more scrutiny. And they're pulling their certificate out and we're comparing it to what they're doing, and we're going, it doesn't really match. And so over the last 5 or 6 years, I've been spending a lot of time working with farmers trying to make their operations match their water rights and make them legal. And there are ways to do that, and that's typically through the change process. And I've been doing a lot of this work because we can't, it's not that we can't, and we have actually gotten new water rights for various things, but it's very difficult to get new water rights. So most people now are changing their water rights to make it more efficient as to how they use it. And that comes down to pulling together a lot of the information that's involved in the water right. I like to tell my clients that, we're going to get all the information, not only information that you get on the website. We typically go to ecology and I go through their data sets, because there are other files, there are other information that they have there about the water right. We want to have all the information that ecology has, because that's where the answers are. And that's where the issues are, if there are any. And so we want to know where all those issues are, where the limitations are, before we actually go to ecology. It also allows us to sit down and try to figure out, talk with the farmer about, okay, what do you want to do? You have another 40 acres over here that you want to get water on. You have 3 wells that you need to add into your water rights that aren't legal in there, that not legal, I don't like that word, that aren't in compliance with your current water right. And we can take care of a lot of those problems, if not all of them, through the change process. But there are ways to lose water during that process too. And Casey touched upon a few of them. There's some relinquishment issues, some perceptions of relinquishment, anything like that. And so knowing about those issues up front before you go to ecology is really a good thing. So you can plan either for the consequences of it, or there's certain ways sometimes to be able to fix those issues over the years and things. So that's essentially what I do. A lot of the information, again, I think Casey touched about it. Somebody had asked, how do people know how much water did we use 20 years ago, or whether we were doing it? Well, yeah, aerial photos review is a good thing to do. We look at that. We can also tell what kind of crops generally that are. We can calculate how many acres it is by looking at the aerial photos, and then calculate, okay, how much water is that? Using the irrigation method at the time. So we can go through all those things. We have a good idea of what it is. Affidavits from other property owners nearby, or people that have personal knowledge of the farming practices, is a great thing. But they need to be relatively specific about what's going on the property. It's not just, I know John Smith and he owned the farm. It's kind of, you need to talk to them and say, okay, what do you know about their irrigation activities? Did they irrigate? What kind of crops did they grow typically? Those kind of things. So you need details to make it, it needs to be, you're trying to build something that's defensible, because it's not necessarily ecology is your enemy. Ecology is the regulating agency here that looks at things. The change process is a very public process. Anybody can question what you're doing at any time, and they can come in there and they can say, we don't think you were using this water. You need to prove it more. So knowing that you can prove things and have good proof before you go to that public process is always a good idea. So try to pull together all that stuff together, get it into 3-ring binders, and hit the next one. We discussed the hydrogeology of the area you're at is very important. It's getting very, very difficult. Casey touched upon a little bit about where you can move water rights to and where you can't based on the hydrogeology. It's getting even tighter these days with the interaction with surface water. And unfortunately in Whatcom County, everybody builds ditches everywhere. And ditches have water in them. And now people are starting to look at some of these ditches and think, you know, are they fisheries things? And then it gets to be even more difficult for moving things around because you can't affect the water in this ditch when you move your water right or something. You know, so it gets complex. Then go to the other one. I think I talked about all those things. But the whole purpose of my job, I guess, is kind of to be the advocate of the farmer, to get everything together, to help them understand what it is they've got, where the limitations are, whether they have any water on the property, how we can get water on the property, and you know, what are their options, and then come up with a plan, prepare the documents, and then submit it to ecology, and that's when the interaction with the consultant on the other side in ecology begins. Any questions on that? Mm-hmm.
Not sure which one you have the answer, but what happens in the case of the subdivision and then a current water right if they split into 4 by the owner of that water right? Or
A subdivision of the property?
Yeah.
Well, a classic thing around here that happens is that back in 1950, you know, Mr. Farmer owned 40 acres and he had a water right on it. And at some time in 1968, he decides he's selling the north 20 to somebody else who's now going to break it up into little residential lots or something and sells it that way. And then it comes to around 2015 and he comes to me and he goes, I want to do something with my water right. Well, now, in order to do anything with that water right, you literally have to get the permission of everybody else who owns property within that water right place of use, because technically they could have a part of that water right. And so it gets complicated really fast. And it takes a lot of time. And people are naturally suspicious when a consultant walks up to their door and says, hi, want to sign this document that says you don't have anything to do with that water right? They're curious as to why that's going on. So it's that's a big problem. But essentially, if again, as what I said, if property within the water right place of use has been sold to somebody else and the bill of sales or somehow it's not written in there where it specifically excludes the water right, the certificate, that person who owns that property potentially has a legal claim to a portion of that water right.
So how do they apportion that? I'm thinking of kind of the opposite of what your example was. Like the farmer divides the property in half and the new owner also wants one. And they each get half of the original water right?
You can do what they refer to as administrative split, administrative division of the water right, and it's there are forms on Ecology's websites. It's actually designed so you can do it without having an attorney involved. It's merely a contractual agreement between you and the other parties as to how you're going to divide up the water right. My recommendation to anybody that does that is that you always have an attorney look at it. It is, to me, it's a property transaction thing, and you should probably have an attorney look at it. But it's fairly straightforward. You fill out the forms. You all agree to how you want to divide it. It doesn't have to be purely on percentage of ownership in the area, but that's typically the way people kind of do it. You send it to Ecology. Ecology does a review of it to make sure that they look to see is the water right valid, is it real, those kind of things. But they don't do a real detailed look into that. And if everything looks okay to them, they eventually will issue everybody their separate certificate.
Can a water right be designated? I mean, like, if there was a farmer who wants to break the land up, is there such things as irrigation water rights, animals water rights, or is it just you can do whatever you want with that water?
Well, water rights have a specific purpose usually, and irrigation is for irrigation. And they can be, the purposes can be very specific. So yes, you have to look at it. And there can be more than one purpose, yes. That could be multiples.
Okay, so I have a water right irrigation, but now all of a sudden I want to put it in blocks. That's totally different.
And you're talking about now using your water right for domestic purposes? Yes, that would require a change in the water right. And in that case, you're going from a irrigation water right, which is usually always a seasonal, so it's not year round, to a year round use, which could be very difficult to do. It may be in his case that if the water use per lot is an exemption, then they're fine. That's again, it also gets down to zoning and a whole bunch of other issues on that. If you have plans on doing that, you're likely it would require, getting some consultants and an attorney involved to help guide you down that path. I'm sorry, you have a question? Oh, okay. Try not to drop it.
Yeah, throw it down. Yeah, let's see here. Okay. So how's it working so far? I just thought we'd give you an idea of sort of the magnitude of what's been going on. Yeah. Well, that's a good question. When did we start doing this? Probably 5 years, 4 years?
Well, I think that the big
Yes. What time is it? Yeah, exactly. Thank you. Oh yeah. Go ahead. Oh, we don't want this on film. Wait a minute.
Probably the big push on change applications that I've seen up here started about 6 or 7 years ago. People started to realize that there was a lot more publicity and people were becoming more aware of the water resources issues, and they started to try to look at their water rights and try to get them in order. But we've been doing change applications and new water rights stuff ever since I started in the business, close to 30 years ago.
Yeah. Okay. I think for these, for RH2, it's been a little less than that, probably 4 or 5 years, I would say, yeah. So in Whatcom County, we've had 35 applications processed, and Ecology has approved 35 of them. They've issued them. Now, one thing I wanted to mention too, a term that came up briefly, I think, was report of examination. When you submit a water right application to Ecology and they process it, or we process it on their behalf as a cost reimbursement contractor, what gets prepared is called the report of examination, or the ROE. And that's like the findings of fact on the application. And it has to answer 4 questions on whether water is available, whether it's a beneficial use, whether that would be anybody would be impaired, and that it's not contrary to the public welfare. And those are the 4 questions. Sometimes they're really easy to answer, sometimes they're really hard, but those are the 4 tests for any water right. Those get answered in the report of examination, and that's the document that, as a cost reimbursement consultant, that's the document that RH2 prepares for review by Ecology. Okay, so we've done 35 of them. They've approved them all in this county, and that's largely a testament to the preliminary work that Chuck does, because like we said, he screens them and said, yeah, you don't want to ask that question, you don't want to go there. And so he provides pretty good applications. And then we have some credit too, because we're pretty good at writing the reports of exam. Andy and I both worked at the Northwest Regional Office of Ecology. There's a lot of staff that are still there. We know what they're looking for. And they trust us because they know us. So we have a pretty good rapport with them in knowing what to expect. And if they have changes, we talk to them about it and work things out. Is there a question? Yeah.
When you say applications, is that just applications transfers and changes, or is that also applications
for new? There's a couple of news in there, but most of these are change applications. Yeah. And then right now we're also currently processing an additional 24 in Whatcom County. And then we have processed 13 in other parts of the state. Again, a mix of new, but mostly changes. I think in the other parts of the state, there's been about 6 that were new, 5 or 6, and then the rest were changes. And they've approved all those as well, and we're currently processing six others in other parts of the state. And so we had 48 statewide, and there was, by my quick count, there was 25 different clients for those, because some of them had multiple ones. And the 35 in Whatcom County, there were 18 clients for those. So some people had one, some people had as many as 8 or 9, as I recall.
100% record of processing.
Oh, I did. But,
yeah, I know. But the thing is a little bit skewed, because if you're in the process, you're not, and it's looking like you're not going to like what the decision
That's right.
is, you have the option of opting out.
Yeah.
So,
But I don't think we've had any that have done that, have we? I don't think we have, but that is an option. If you're an applicant, if you're an applicant, because one of the things we do is we write the draft. We show it to Chuck and the applicant and say, did we get everything right here? Did we describe what you're doing with the water, what you want to do with the water? They have a chance to come back to us. We go talk to Ecology about it. If they say, yeah, this isn't looking so good, we go back and tell them, and it's either a problem we can fix, or it's a problem we can't fix, in which case the applicant can just say, never mind. And they're done as far as Ecology is concerned, and they walk away or make another proposal or whatever. So that's a good point. We haven't had those yet, but that is an option. But that makes applicants more comfortable, because they are leery of what might come down the pike. And so there is a bailout sort of option sort of all the way along the way. Okay, I think that's the, okay, yeah, the average cost that we've charged for application processing. Have a question? Oh, sure. It varies a lot, because there's not a huge number of hours in each one, but there's always delays, and plus we're working on a bunch of other stuff. This isn't everything I do, and we're processing all of them. Typically, probably, what would you say, 6 months from the time we get it?
yeah, I think that
Probably about 6 months when we get it, and then Chuck does work ahead of time.
the fastest one I think that we ever did, and we did have some upfront knowledge that we were going to have to try to get this thing done really quickly. I believe that we were able to get it into Ecology, get you guys through the contractual issues, and get the decision a little over 5 months, but that was almost a miracle.
Yeah.
And yeah, I would say plan on between 6 months and a year. And that would include the upfront time that I would be involved, or whoever you had involved up front on it.
And we've found too that there's sometimes where we find that we need additional information. We go back to the applicant, and they're harvesting berries. They don't have time to answer that question, so we wait. And in fact, what we do in our fee estimate is we usually put about a 10% contingency fee on there, just because my experience in water rights is there's always something that comes up. And one of the things that can come up is delays in getting the application, getting the information. So if you're looking at 6 or 8 water rights for an applicant, and you've got into it, you've studied, you know where the wells are, you know what they're being asked for, but you need some additional information and you don't get it for 2 months, you're not going to remember those 6 applications, and you're going to have to get back reacquainted. So we have actually talked to Ecology, and they've bought off on having a contingency fee in there for either things you didn't see coming or delays like that where you have to get reacquainted. And we don't use it without the written approval of Ecology. And we've had a few cases where we've used it. In most cases, we've not. And so we've got a track record with them that they know we're only going to request it if in fact we need it. But it's been a real lifesaver in a few cases where we got back in and had to get reacquainted with the project. So the cost varies. Its average is about $7,000. It varies based on a number of factors. If you have more applications, the total cost is more, but the cost per application tends to be less. If you've got 5 wells and they're all in the same vicinity, you do the hydrogeological work, and probably it's going to be the same on each of those wells. There's been a couple where we found that 2 of the wells were on one side of a groundwater divide and flowed toward one creek, and 3 others flowed the other way. That's the stuff that Chuck helps us find out. So it's not always real straightforward, but generally speaking, there's some efficiency of scale of having multiple applications in terms of the cost per application. And then, of course, it just depends on the complexity of the request. What is the hydrogeology like? Is it a real complicated area or a well-known area, or is there not much data there or a lot of data? How close is it to surface water bodies that are closed or have salmon or steelhead resources in them? What other water rights are in the area? Do we have to look at other water rights? And we do look at claims when that comes up and try to do a rough assessment of whether or not it looks valid. And like Casey said, if it's a surface water claim that should have been for a use beginning in 1917, and it says we started using the water in 1983, probably not a valid claim. But again, that's not a formal finding of the claim unless there's an adjudication of water rights. So it just sort of depends, but that's the process that's been working, and you know, the clients are certainly been happy with it. They've got a lot of their water rights lined up with their actual use, and that's really important because if, for example, there's ever an adjudication in this basin like there has been for the last 35 years or whatever in the Yakima, ultimately a judge is going to look at that and say, where are you using water? Where's your water right for that? Is your use consistent with your water right? And if it's not, then there's going to be some adjustments that need to be made that may be fairly painful. And so these guys are doing the right thing to get their water use matched up with their water rights. So, you know, you have a choice if they don't match up. You can either change your water use back to what matches the water right, or you can change the water right to match your use. And that's usually the one they want to do because they've put in infrastructure and, you know, a lot of expense and so on. So it's clearly most of the time it's the thing you want to do is change the paper to match the real world. So next slide is just our contact information. And we do have, depending on what questions you ask, we do have some slides that are kind of depictions of a few of the kinds of scenarios that we've dealt with in the change application process. So if we want to go into those, we can, or we can just field, the three of us can field questions. So either way. Yeah.
Yeah, earlier on, there was a question from somebody in the audience about where the lumpies fit. Could you talk a little bit about federal reserve rights?
Sure. Nobody here from the tribe? The tribes claim a federal reserved right. When a federal reservation is created, it's been found to include waters necessary to meet the needs of the reservation. The question becomes, and that includes Army bases, national parks, Forest Service lands, and Indian reservations, and any other federal reservation. So the question immediately becomes, well, how much water is needed to meet, what's the need, what's the purpose of the reservation of land, and what's the water needs? It's reasonably straightforward if it's a military base or something like that, but not so straightforward when it's an Indian reservation, because, you know, is it the agrarian use of the land? Is it just for irrigation and farming? And is it only from hand-dug wells and surface water diversions because they didn't have pumps and so on to, you know, pull deep water out? Or is it whatever is available now? Can they expand their use to be, you know, other homeland purposes? Can they put in a water slide theme park? There's just a whole bunch of different questions, but it's been found that they have a federal reserve right for water sufficient to meet the needs of the reservation. In addition to that, they contend and have been found in a number of places to have a time immemorial water right, which is like priority date 0000, to flows for in-stream flow for fish and wildlife. And that's the claim that the Lummies and Nooksacks have asked the federal government to issue a declaratory judgment to say, yes, you've got X amount of rights to flow in the Nooksack. They haven't done, the federal government hadn't done that yet. They haven't said they will. And so the tribe has been, I haven't been party to these discussions, but I've heard from a number of people sort of a consistent story that they are talking about some alternative ways of managing the water in the basin. And I can't say I'm not speaking for the tribe, but what I've heard is that they're fairly okay with diversions of water from the main stem of the Nooksack, but they want to get water use in the tributaries out of the tributaries. So for example, if you've got farmers in Bertrand and Fish Trap Creek, even if they're taking groundwater, if that's in continuity with the creek, they would like to get them onto water that's diverted directly from the Nooksack. So it's not being taken out of the tributaries, and perhaps there'll be some recharge capability when they put water on the crops, and it, you know, you get some return flow and so on. So it may actually enhance the flows, but they won't be depleting the flows. There's obviously infrastructure implications for that, pumps and pipes. Now, as a civil engineering firm, we say, yeah, that works. We can design pump stations and pipes, but somebody has to pay for it. And so that's really, you know, one of the big issues that I think is going to come up with that. It makes some sense from a fishery standpoint to protect the small stream tributaries, which are important for salmon, and take the water out somewhere else. But the infrastructure costs are pretty significant. And so I'm not sure what's going to happen with that. Somebody else also asked about possible future projects or things that are going on. There's a lot of interest in providing water to the areas north of Linden that have high nitrate, and there's a lot of public water systems up there that are drinking high nitrate water. And Birch Bay and Blaine just got I think it was a $700,000 grant from the state to look at deep well development. Chuck's involved in that too. And they're going to try to start punching some wells east of Blaine. They know there's some old saline water out there that's not suitable, but Blaine's also on a good deep well system. So they're going to try to find out where the demarcation zone is between the good water and the bad water, and see if there's a supply of water there that then could be used to supply water out to the North County area. So that's one of the things that's being looked at. Somebody also asked about buying property. And I guess a couple things I would say on that is, if you're looking at a piece of property that has a water right document, you know, they can show you, here's my water right certificate. That may be worth a lot, and it may be worth the paper it's printed on. And so I think you should always check to find out, number one, what's ecology think about that water right? Because you may find out when you pull up the database that it was canceled years ago. It doesn't exist anymore. It's still in the database, but it's not a valid water right. Or you may find it's in there, but that's when you got to start looking at the historic use that Chuck talked about and Casey talked about, to see what is the water right. If you buy water in forms of a water right, let's say you're buying a piece and you want to move that water to another parcel, you're going to want to transfer it. Do not buy the quantity of water that's on the document unless you have confirmed that it's good and valid. If you want to agree on a price per acre foot that's approved for transfer by ecology, you can do that. That's not a bad idea. You can say, I'll pay you, you know, $500 for every acre foot that ecology approves for transfer, but maybe they're only going to transfer half the water. Isn't that water right? You don't want to have paid for 100% of the water at that price. So always connect it to what's really going to be available to you, or you can really get hammered. And I've seen both cases happen, and it's a lot more pleasant when it's the second one rather than the former one. So that's just a thing to watch. Make sure you're talking about wet water, not paper rights, because that's a real trap to fall into. And to be honest, real estate agents aren't very good about that. So it can be a real trap. I think that was it. If there's any other questions for any of the three of us, Eric.
I know this discussion today is on water rights. Your company is considerably not water use agriculture. That's not.
Mm-hmm.
And as far as no one really knows how much it is, or the extent of the lack of compliance with state law. Maybe it's just a little difference in the certificate says county, where it's actually, or maybe at the other extreme, it's just I'm gonna punch the well with more irrigated. They don't have any right at all. Is there any sense of how big a problem it is, and how this might be resolved in a way that meets the needs of the farmers, but also respects environmental quality and fish habitat and Native American treaty rights?
Casey? No, it's true, and I don't know. I've worked in this county a long time, and I hear different numbers about how much of farming is illegal. And you're right, it ranges in a spectrum from no water rights whatsoever, maybe using a little water, maybe using a lot of water, to fairly minor changes, like they're using it over here instead of over here, technically it's not exactly legal, but there is a fundamental underlying right to use that quantity of water. So it's all over the board, and that's the difficulty of trying to figure out, you know, what it is. And no, I don't know of an overall program to try to get there. It's going to be a little bit at a time, as you figure, you know, look at individual water rights and so on. Now, you know, I think you can kind of get rough pictures if you, for example, look at aerial photography for the county and figured out what farmland is being irrigated during certain times of the year and figure out what crops are there. You can assign water duties, as Chuck was talking about. So I think on a gross scale, you could look and say, okay, there's, you know, I'll just pick a number, 8,000 acres of irrigated agriculture, and 2,000 is corn, and 3,000 is grass, and the rest is berries or whatever. Assign a water duty to that, and then add up the water rights on within that area and see how they match. But it won't tell you this parcel's got a problem, this one doesn't, and it won't. You know, if you just look at the water rights, there may be a surplus somewhere where it's not even being used. I mean, that'll give you a kind of gross picture, but it won't help you go out into the field and say, okay, I got to talk to this guy and I got to talk to this guy. It just isn't going to happen that way. It's a very data intensive effort. Anything you want to add to that? Hey, thanks.
The only thing I would add, just quickly on that, is that there's been many times when I've looked through and pulled up water rights and looked on properties, and I find out that people have two valid certificates for a lot of water that overlie exactly the same parcel. Okay, and they're both valid. They're nice certificates, and you ask the question is, why would ecology grant two water rights that overlie the same area? That's always been one I've wanted to ask, but nobody works at ecology now that was there back in the 50s when they did a lot of those things. The owner of those water rights looks at it and says, well, wow, I've got 5 feet of water per acre here. Look at my water rights. And you kind of go, and this is kind of leads to what Jim was saying about you can calculate out how much water is actually needed. And that actually has been done by various people. Joni Greenberg probably could give you numbers on that in the county on any given year, roughly how much water is being used by agriculture based on the actual crops that were grown. But trying to reconcile those against the water rights, even the certificates that are in the database, is difficult, because the fact of the matter is those two certificates are only valid for the amount of water they've been using. And they sure as heck haven't been using 5 feet of water per acre. They're probably less than 2 feet in that area. So, but if you're just going by the water right numbers, the paper numbers that are on there, it looks like, wow, there's lots of water. Mm-hmm. So there's all sorts of limitations to that.
And that's why one of the reasons, if you did a general adjudication in the county, and I don't happen to advocate that because of what it costs and how long it takes, but basically what happens there is in Yakima, for example, every water right user was required to go to court and say, here's my water right, here's what I'm using. And like I say, they only did surface water, and it was going when I went to work at Ecology in 1977. And I think they signed the final orders just like 3 or 4 years ago. And they didn't do groundwater. They just did surf. Is it still not completely done? Okay. Okay. So it's, you know, it's a huge, massive undertaking. There's been some bills in the legislature to try to streamline it, but it's a very data-intensive effort. Everybody, under the current law, everybody has to go to court and hire an attorney and go to court and say, Your Honor, here's my water right, here's my water use. And then there's a referee that's appointed. Ecology usually is served in that function. They have to look at every one of those and do ground truthing to see if that's really what's going on. And then the referee files a report, and everybody has to comment on that. And there's been some bills to streamline that, where saying that if you disagree with the referee's report, you come to court. But the legislature hasn't passed that, so excuse me, everybody has to come back to court. And it's just tremendously expensive and time consuming. And, you know, when we first started a project here in the county years ago, when Ecology first opened the field office, we did a state of the watershed report. And a guy came from, he was the water master, or the state engineer from Montana or Wyoming, and they had just finished an adjudication there, and the first children born to the staff that were doing the adjudication had just graduated from college. And the judge finally signed the order and said, good, we got it. Go make this happen. And the guy said, and everybody that was involved hated each other by then, because there'd been so much animosity during the previous 23 years of trying to sort out water rights. Now the judge said, great, this is great, we got it done. Go work together and make it happen. And he said it's going to take years to do that. And so he was saying, yeah, don't do an adjudication. That's not my recommendation. So, you know, I really think and have thought for a long time that a negotiated process where I personally think, my own personal view is that to solve the problems in the Nooks Act that relate to tribal water rights, you really need to look at restoring the riparian function of the river system, get certain uses out of the floodplain, compensate the farmers if they're losing land and so on, get the river functioning, because there's places where you can put a lot of water back in the creek and it's not gonna make any difference because there's not habitat, and there's places where the habitat's pretty good but needs water. You need to tailor what you're doing to what's needed at that place, and that's what I think it's going to take. It's going to take a long time and a lot of money. So that's just my observations from kicking around in this basin for 20 years and in ecology before that for a long time. So for what it's worth, there you have it. Anybody else? Yeah.
Jim, I'd like to go back to the question about the young farmer, the new farmer, trying to determine water rights on property.
Mm-hmm.
Looking at, because I think it's kind of the point of a lot of the discussion.
Mm-hmm.
And we've certainly got a sense of how many variables there are in answering that and all the complexities. So is this something someone should be expected to do with the data that's available from ecology? Or will ecology give them an assurance at the end of the day once they've looked at everything? Or do they necessarily have to hire you or a consultant to help them with that? Or can you give them a little more guidance?
Yeah, I think it's a combination. It'll depend kind of on what you have. Certainly getting the full record from ecology is important to see, get the whole water right file from them. And so you've got everything there that you can see. And then I think talk to the owners that currently have it, find out what their history of water use has been. And, you know, if they can document that they were using the water, you know, historically, that there hasn't been a period of relinquishment or non-use, you know, or they're not irrigating 30 acres and their water right says they can do 10, you know, that should be an alarm. But if the water right looks pretty good in terms of what's actually being used, then I think you try to document that with the property owners. You can get affidavits, sworn affidavits from them that say, and we do that, Chuck does that quite a bit. We use that in our change application process where we have neighbors and the applicant do affidavits and say that property was logged in 37 and it's been in corn, you know, ever since, that kind of thing. And that works, that counts. I mean, if it's wrong, if they lie, they're perjuring themselves. So, but it is used as evidence for those kinds of things. And so I think it varies depending on what you can find out, but I do think you want to build the best case you can. And I can tell you that I wasn't a permit writer for ecology. I was in policy stuff and supervised permit writers for a while and so on. So I wasn't always hands-on in water rights, but I can tell you that in my career, the number of people that came into me with water rights documents and I felt comfortable saying right then and there, this is good, was one. There's a guy up here in Whatcom County, and he came in and he had a water right document, he had aerial photos, he had affidavits from his neighbors. The guy that he bought the property from was the original water right applicant. It hadn't changed hands. He had been there, you know, for 30 years, had farmed it every day himself, sold it to the new guy who was now going to take it over. And I said, yeah, this looks good, but it's not very common that it's that straightforward. The facts may still bear themselves out. There certainly are valid water rights out there, but this was actually the only one I ever had that was like, man, you got this covered. And there really was no real questions about it. And like I say, a lot of times there's questions, a lot of times they can be answered satisfactorily, but many times you have to dig in more to do it. Does that kind of get at your question?
just to add one little thing on that. 80% of the work I do on water rights, I didn't learn any of that in college. It's data research. It's pulling data together. It's something that anybody can do. Probably even more than 80% of most of them. There is a hydrogeology component of it that requires my technical expertise. That's about it. And in some of those water rights, you don't even need that. It's just a matter of pulling everything together. Several years ago, I was under contract to the Birch and Wood, and I wrote a manual. It's a farmer's guide to water right applications. And it is about this thick, okay? But it's mostly ecology guidance documents on what things mean. They have a lot of wonderful documents explaining water rights and things back there. It's got the water code in it, and it also has my attempt and only attempt at creative writing in my life of a story of a farmer who is going through the water right process and how he pulled together everything by himself and did everything. And if you can contact Henry Bierlink at the WID, I think he could probably find some of those. If not, I certainly have electronic copies of them. I could provide them to Henry and he could distribute those. The intent was to get those in people's hands so that they can actually do most, if not all of this themselves. They don't need consultants for a lot of it. It's time consuming. Is really what it is, more than anything else. You have the mic.
Thank you. Thank you. I just wanted to say from ecology's perspective, we are more than happy to get calls, emails. People walk in and request technical assistance all the time. I love to provide that. I probably am not likely to be able to certify, this is a great water right for you. What I can do is tell you what to look at, things that may be concerning or not concerning, but that evaluation is going to have to be yours if you're just looking at a land transaction. But we can definitely provide technical assistance to folks. And in terms of, I felt that probably we should have done a bridge between myself and Jim. There was something else I didn't have an opportunity to cover. Jim and Chuck did a great job of talking about cost reimbursement water right applications. The one thing that I didn't have the opportunity to talk about and explain that for is, we touched on it briefly, is that Jim mentioned there's like over 600 applications backlogged up here in Whatcom County that need processing. We have for King County, north up to Whatcom, and then all the way out to the San Juans, we have the equivalent in permit writer staff at Ecology of about 3 staff members for that entire region. And these, you heard Jim, somebody asked the timeline question, how long it takes. It takes many, many months. That's because these are very involved matters these days. Involves a lot of analysis, a lot of legality, a lot of investigation. So these aren't slam dunk, you just type a couple things into a computer and push it out. They're thorough analyses and take a lot of staff time, which is unfortunate. So we have a backlog. We have, like I said, about 3 people to do this giant part of the state. And so we shift around parts of the state where we're processing and working on the water rights. So that has created a situation where we have more that have come in than we are able to push out the door. So there is this backlog. So one of the ways to not wait for our staff to have the time or be working in this portion of the region is to go through this cost reimbursement avenue. And we also have technical guidance, paperwork, all about it on our website as well. So if you are considering something like that, there's information on it, but no, it is absolutely not required. A general application just costs $50 to get it processed through Ecology. But there may not be the expediency that you need or want for your project. Sue had a question.
So given the backlog that's out here right now, if somebody wanted to put in another application for change or something and wanted to just take the risk of however long it takes without going the route with Jim or Chuck, do they end up at the back of the line?
It is by priority. Yeah, all the applications that come in are prioritized.
For new rights versus changes?
Changes retain, and we didn't have a chance to go into all the fundamentals of changes, but because they are part of that, one of the requirements I mentioned is that it has to be the same body of water. One of the other items is that, and Jim mentioned this, is it can't impair other existing rights. Part of that is you're retaining your original seniority date. So if it was processed in you originally got a certificate in 1952 and you're changing it today, you're still going to retain that 1952 priority date, because you should not, if it's approved, be impacting any other water rights in any other negative manner that are less junior to you.
I was just reading that there's about a 10-year backlog of new applications for new water rights. That somebody that's applying for a change, they have to wait that amount of time?
Not necessarily. We do have a backlog of changes that I believe is somewhere between 60 to 80. So there is a backlog for we have those 3 writers for new and change applications. One of the more expedient routes, though, is to do a seasonal change application, in which we are able to process it. It's for 1 season only. And those can normally get completed if you have it into us by January. We're normally able to process it before the irrigation season. There's some efficiencies with that. So that's a seasonal change application that's just for 1 season only. And so that's a couple months.
So then the more of those that are getting processed, so if more people apply for changes and those are prior to the new applications, does that extend the backlog of new applications because we only have so much staff to process them?
There's the potential for that. And I wish it wasn't. I don't enjoy being able to say these timelines to you. I'm a person that likes to get things done, and I'm a person who likes things to be successful. And so it's hard to be in the position where I do have to say, yeah, this might take a number of years. I will say a lot of the backlog that we have up here, we anticipate those being water right applications that would be denied. So rather than expend our limited resources processing a permit that on the face of it looks like it's going to be a no, but it's still going to take staff 3 months to complete, we'd more likely probably work somewhere where we think there's more likely to be a legally defensible yes answer there.
What are some examples? I mean, if it's applications for new rights, what are some examples of like no's? You know, I mean, like.
So if it's a new water right that's to any of those surface waters that are closed,
Yeah. Well, yeah.
or any of the groundwater that's connected to it,
that'll take time. That'll take a few months to review, even if it's sort of an obvious. That's an awful list.
we are required to go through the same thorough analysis, have the publications in the newspaper for all of those. So if we see that, we would encourage somebody to withdraw that application, but they don't have to. They could still want that processed and have us evaluate it. Yeah.
The one thing we kind of touched on for just a moment was the seasonally accessible water rights. And we made the joke about that not really being available for the irrigation season. Can you kind of talk on that a little bit more? And how often are those made available when they're necessary? And how's all that breakdown?
Tell me more. I think I wasn't quite following that
like
one.
the seasonally accessible.
The seasonal change.
Closed
Oh, for the map that I showed. And so your question was, okay, I've got that in my head now. Now what's the question?
So if those aren't necessarily accessible during the irrigation season, when are they? How often? What does all that look like? Because you could have water rights not be able to
So we wouldn't likely, if you wanted, for example, an irrigation water right in the traditional irrigation season and you're in an area that is closed seasonally, we would not approve it. If for some reason you wanted a water right in December and it's only closed April through October, then maybe we would be able to grant that. Unlikely for an irrigation purpose, it would be for something else, if that makes sense. Any other questions? Well, you guys have been more than patient giving up your sunny afternoon to come listen to Water Talk. Thank you for all coming.